Good afternoon, everybody. Thanks for joining us for a special webinar session in our OSHA webinar series and Labor and Employment webinar series for 2021 at Con Maciel Carey. I think it was Yogi Berra that said, it's like deja vu all over again. Many of you working together with us over the course of the spring and early summer on federal OSHA's COVID-19 emergency rulemaking. We thought that process was over and in the books, but here we are again talking about a new emergency rulemaking by federal OSHA, and this feels like a very significant development in a situation that I'm sure we all hoped was coming to an end earlier this summer. Today, we're going to be talking about President Biden's announcement last week and his new action plan to battle COVID-19 through the fall and winter of this year that included a new directive, a second time in his short presidency that he has directed federal OSHA to take up an emergency rulemaking, a very, very infrequently used tool by the agency, but now to be done twice in 1 year. I'm the first faceless voice you're hearing today is Eric Kahn. I'm one of the founding partners at the firm, and I chair the firm's national OSHA workplace safety practice group. I've practiced for over 20 years in this field, including the first decade practicing alongside the former first general counsel of the OSHA Review Commission. And I thought for the first 20 years of my practice that I was an incredibly specialized lawyer focused on workplace safety and health issues. The last year and a half, I've become even more specialized, become a COVID-19 OSHA lawyer. It's been remarkable, but I've had quite an experience collaborating with the other co-chairs and the rest of the team at Con Maciel Carey of our COVID-19 task force. And I'm very pleased to be joined today by two of the leaders on our task force, and I'm going to let them introduce themselves here.
Thanks, Eric. Hi, everybody. My name is Kara Maciel. I co-chair the COVID-19 task force with Eric and Aaron, and I co-founded the firm with Eric. Now we're celebrating our 7th anniversary this month, actually. So it's been a really great time. I lead our labor and employment practice, and I don't think Eric and I could have imagined when we founded this firm what a synergy our two practices would have in 2020, 2021 in terms of highlighting the importance of labor and employment issues and workplace safety issues in response to COVID-19. So it has been quite a learning lesson for me as well over the last year and a half, but it's been exciting and really great to be at the forefront of these issues, addressing really timely and important and novel questions of law and regulation for our clients across the country, big and small, nonprofit, for-profit, global, local, small businesses, and look forward to continuing to talk about this as we are facing what we think to be, a new ETS for private employers.
And thanks, Kara. And this is Aaron Gelb. I am based in Chicago, where I lead the firm's Midwest OSHA practice. And I guess I kind of embody that synergy, since I also handle employment litigation matters out of Chicago as well. It's been, I think I've been with the firm just about 4 years, half of it seems like in the pandemic. So it's been two very different kind of periods of time, I guess, since I've joined. But it's just to echo what Kara said, it's been invigorating and challenging, but it's certainly something that I think, as we see with this ETS, that we have a real opportunity to hopefully share some of the knowledge that we've gathered with everybody, and answer your questions and be a resource for everyone. So I'm glad to be able to be a part of this webinar, and look forward to getting into this discussion with you all. Thanks.
All right, so we've got a pretty focused agenda for today. The president made his big announcement, and in combination with that, released an action plan that includes executive orders and, in particular, a directive to Fed OSHA to issue a new ETS. So we're going to talk about what to expect in this new emergency rule that OSHA will issue sometime in the, quote, coming weeks, as the president has indicated. And then we'll get into the frequently asked questions we've already received about this emergency rule, and share with you what we know, what we think, what we guess, what we have heard from our friends at OSHA, and try to give you as much of a forecast as we can about what to expect in this emergency rule. So jumping right in, this is the name of the document that the White House released on Thursday, The Path Out of the Pandemic, President Biden's COVID-19 Action Plan. In this new action plan and in his announcement last week, President Biden introduced a 6-pronged plan to combat COVID-19 through the balance of the year. And you can see, the other 5 elements of the action plan, but the main one, and the one that affects us the most from this OSHA perspective, is vaccinating the unvaccinated. That has been a high priority for the president, rolling out the pandemic program since he was sworn into office. And he's grown frustrated and said as much in his speech on Thursday with the number of Americans who are eligible for the vaccine, who have ready access to the vaccine, and who have not been vaccinated. And so he's taking action. And whether or not this action moves the needle, I think it certainly will in some sectors. It remains to be seen in others. But I think this is one of those situations where he wants to be caught trying to take action, whether it works or not. He wants to be seen as doing everything he possibly can. It was his campaign centered around, I'm going to be the one that gets us through this pandemic. So he's pulling out all the stops, and that's where we are now. Within that prong of vaccinating the unvaccinated, there are 5 components, 5 goals. And I'll just introduce the first few, but we'll focus today mostly on this final one about the soft vaccine mandate in an emergency standard from OSHA. But the first few, I think, really reveal what the president's desire is, that if he believed he had the legal authority to do it, he would be introducing a hard vaccine mandate in many, many other circumstances than he did, but where he, I think, has some confidence that he's on solid footing, he's able to require vaccination with no other alternative, or vaccination with the only alternative that you leave your job, don't do business with the government, don't accept federal funds. So in those 3 settings, if you are a federal government employee, vaccinated, or you have no job, or if you're a federal contractor, in many circumstances, there's certainly threshold limits in terms of the size of your contract relationship with the federal government, timing. This applies to new contracts that will kick in mid-October, or amendments or material changes to existing contracts, and to some extent, whether you are physically present and interacting with a federal installation and federal workers, there's a hard vaccine mandate. And the idea there, I'm your boss, or I'm entering this contract to pay you money from the federal government to a federal contractor. I get to set the parameters, and I expect vaccination. The other area where we're seeing this hard vaccine mandate is expanding an existing hard vaccine mandate in the healthcare sector. Right now, nursing care workers who accept Medicare, Medicaid reimbursement have been required for a little while now to implement a hard vaccine mandate. You get vaccinated, or you cannot continue to operate and receive Medicare, Medicaid reimbursement. So it's effectively, you get vaccinated or you leave this job. They're expanding that now to the rest of the healthcare sector, where there is accepting of Medicare, Medicaid reimbursement. So this is going to move beyond nursing cares, out into hospitals, out into outpatient care settings where there's patient interaction and acceptance of participating in the Medicare, Medicaid program, essentially. The other area where we're seeing a hard mandate is for educators in participating in a federal Head Start program. Again, you're under this federal program, accepting federal dollars. You've got no choice, vaccine or no job. The other aspects of this, of the action plan, include encouraging state governors to set mandates for educators and staff in state regulated schools, public schools in the states. But that's not a mandate, presumably because he believes he doesn't have that authority to do that. He's also encouraged entertainment venues to require patrons to be vaccinated. So concert halls, sports arenas, get vaccinated or show a negative test for entry. That's an encouragement, not a mandate like these others. But the big one, the one that we want to focus on today principally, is the directive to federal OSHA to issue another emergency temporary standard. This time, surely it is intended to apply beyond just one individual sector, like the healthcare sector, like the emergency standard we saw in June, but to apply to employers covered by OSHA who have 100 or more employees. It will be required to do several things, but principally it has set this soft vaccine mandate. And we'll get into what that means here in just a second. What will be required? And again, this is something that hasn't been written yet. And just to give you a little bit of inside baseball, we heard from our friends at OSHA that as of the time the president was giving his speech in the afternoon last Thursday, almost the entire agency, the career folks at OSHA, had no idea that this announcement was coming. They were hearing about it the same time we were. So the folks that ordinarily would be drafting regulations and meeting to decide policy goals of regulations were not working on this. There had been no pen to paper about this rule as of late last week. Some of the political officials at the agency, we understand, got a little bit of advance notice, but this is not a rule that was in the works. The prior emergency standard, even before the president was sworn in, knew that this was coming and began working on it and had time to lay some groundwork and to do some thinking and sort of debate policy strategies for the rule. Not the case here. So what will be required? We're going to give you our best guess based on president's announcement, based on the action plan that was produced with it, based on discussions we've had with people at OSHA, and based on sort of a historical view of how OSHA regulates and their legal authority in this area to regulate, to what we think we're going to see in this rule. But it's all subject to change. And I think the answer is, even if you were asking, the head of OSHA, the acting head of OSHA, or asking the individuals in the rulemaking directorate at OSHA, their answer is going to be barely more definitive than ours on a lot of these questions, because I don't think that any of this is settled quite yet. But we'll talk about what we know and what our expectations are. What we know from what the president has said and his action plan is that there's going to be two major components to this rule. One is that employers will be required to provide paid time off to employees to get vaccinated and to recover from any ill effects of the vaccine if they feel fluish for a day afterwards. There's some indication from the action plan and discussions we've had that there is going to be a finite amount of time that is assigned to these paid time off requirements, that there's an expectation of about 4 hours of paid time to get vaccinated each time, right? If it's a 2-dose vaccine, 4 hours for the first dose, 4 hours for the second dose, and 8 hours, a full workday, to recover from the ill effects if you have ill effects for each dose. So we're talking about a total of about 3 paid days for employees to get vaccinated, for those who get vaccinated, we think, after the rule goes into effect. This would not be a retroactive requirement to reimburse employees for time spent getting vaccinated prior to the rule. We think, that would be, I think, strain the agency's jurisdiction and authority to be retroactive. So that's why our expectation is it's going to be a forward-looking requirement. The other piece of what we think will be required in this rule, based on all indications, public statements, and discussions we've had, is the setting of what we're calling a soft vaccine mandate. And that means that the employers will be required to, before they allow an employee to report to work, either be fully vaccinated, get fully vaccinated, or demonstrate that they already are fully vaccinated, or require a negative test on a weekly basis. So we're going to get into today our predictions about who is going to be paying for that test, what type of testing is allowed, it's going to be acceptable to demonstrate that you are COVID negative for the week. And we'll get into that, but at a high level, that's the requirement. Paid time to get vaccinated, and get vaccinated or get tested on a weekly basis to be able to report to work. Now, I don't think we can leave this discussion about what will be required without at least flagging the possibility that OSHA will revisit its decision from June to issue the more comprehensive COVID rule narrowed only to the healthcare sector. They did that at a time where cases, hospitalizations, and deaths were falling off the cliff. Vaccination, the daily vaccination numbers were looking great, and the effectiveness of the vaccine was looking great. We weren't really talking about breakthrough cases at all at that time. The CDC was issuing guidance to say vaccinated people are safe. You can take off your masks, and it doesn't even matter if you're sharing a soup spoon with an unvaccinated worker next to you. You're fine. Go about your business. That was the time, that was the landscape when OSHA said, all right, this rule about written COVID plans, this rule about working on your ventilation system, this rule about masks and distancing and pre-work screening and all of that good stuff is going to be narrowed only to healthcare, because there remains this unique risk for people whose job it is to work with known or suspected COVID patients. We don't need a rule for the rest of industry because it looks like we're rounding the corner and we're going to defeat this thing. Well, obviously the landscape has changed, right? The CDC has revisited its guidance about masking for fully vaccinated individuals. We're learning a lot more about breakthrough cases. The Delta surge, which at the time OSHA made its decision in June, Delta variant represented, I think, less than 5% of the cases in the US. Now it represents almost every case that we're seeing in the US. The landscape has changed. And I think OSHA probably, if they were making that decision today about the more comprehensive rule, would probably issue a rule that applied beyond just healthcare and maybe applied to every workplace. So it's possible that now, with a new rulemaking underway focused on COVID-19, that OSHA could revisit that decision and either in this rule or in parallel issue a broader rule that covers all of those administrative and engineering controls and written programs and record keeping and reporting and all that good stuff. My guess is that this rule that we're talking about today will not get into that. That this rule that we're talking about today will be narrow in scope, narrow in its, in the regulatory requirement to just focus on this vaccination and testing issue, if for no other reason than speed. They want to get this rule done quickly. The president wants them to get this rule done quickly. And we know that OSHA doesn't do things quickly. And to the extent they're doing something broad and comprehensive, that would slow things down for sure. So I expect, if for no other reason than that the rule will be focused on vaccination and testing. But I think it's important to flag this issue that the bullet that we dodged back in June may well be a boomerang that's coming back at us now. And I think we've got to be careful about that. I'm going to hand it over to Kara to talk about who we think is going to be expected to pay for vaccinations or really for testing.
Thanks, Eric. Yeah, I mean, this question is a really open-ended question, and we don't have some definitive guidance, generally because Biden's announcement and the action plan, they don't say whether it's the employer or the employee who's responsible to pay for the testing, but we've got some clues, at least in Biden's action plan, but we've also got some inside knowledge too, and generally understanding of what the Department of Labor, what Biden's purpose is in nominating some of those individuals, and his goal, particularly as it relates to labor unions. So if we first look at the language of his action plan, really most of the elements of the plan speak in terms of the employer's affirmative duties, right? Here we're talking about the employer has to provide paid time off for work when they need to get vaccinated or to recover from the ill effects. So when President Biden wanted to be clear that it was an employer obligation, he knew how to do that, and he made that pretty clear. But when he talked about testing, he referred to workers who remain unvaccinated have to produce a negative test result. So this concept of the worker has to produce the negative test result converse with the employer who has to provide the paid time off, to me indicates that there could be an opportunity, or at least when Biden announced the action plan, at that time there was a thinking that it really is probably going to be on the employees to pay for testing. On the other side of that coin, let's go to the next slide. we talk about how Biden really, and Eric touched on this point, is pretty frustrated with the unvaccinated. You know, he's come out and said, you know, we've made these vaccinations free and safe and convenient. It's FDA approved. We've got 2 million Americans who have been vaccinated. We've been patient, but our patience is wearing thin, and your refusal has cost all of us. So this mandate really is focused on the unvaccinated, as we touched on in the 6 points. And so he wants it to be hard for employees to refuse the vaccine. Essentially, we think it would be too easy if they didn't have to pay for the testing if they didn't want to be vaccinated. So we have heard from other people that people in the CDC would have gone further and not allow this off ramp for testing, but that Biden really didn't want to make it a hard mandate for the private workplace. On the other side of that coin, though, we've got a thinking that it could be a shift in the change from the Department of Labor and OSHA in particular, that employers will have to pay for the testing. And that's because we know that President Biden, when he's running for election, he has promised to be the most pro-union president of any president in history. He's done that by nominating a very pro-union friendly secretary to the Department of Labor, Secretary Walsh. The acting head of OSHA currently, Jim Frederick, he used to work for the steelworkers. So we've got very union-friendly members that are working on drafting this rule. And what I think we're going to hear is they're going to get pressure from major labor unions who are not against encouraging the vaccine. We've heard statements from a variety of different labor unions that said, look, we are encouraging our members to have this vaccine and we want them to be vaccinated, but we disagree with a mandate. And if it is going to be a mandate, it needs to be bargained with our union members. So I think what we're starting to hear is potentially a shift from the Department of Labor, that it could be more of a burden on employers and not the employees. So that could be the issue here. And I think one of the things that we'll talk about at the end is the importance of making industry's voice heard to the Department of Labor and to OSHA when they're considering this rule. They're hearing it certainly from labor unions, but industry needs to say the challenge if employers have to pay for the testing in light of other things that we'll talk about, the availability of testing, whether it's compensable time for employees when they're testing. So really it's going to be a question of, can we get, if we don't want them to, employees to pay for it, if we want employers to follow the way President Biden said and just have it produced, then we need to have a voice in front of the industry. I think that one of the strongest arguments for employees paying is the high cost. It's more manageable for employers than employees, but then that's also a question of, is Biden going to be able to get retailers to lower the cost of the testing? I've also heard from clients that health insurance are stepping up and are willing to pay for the cost of the testing so that it could be a zero cost for employers and employees. So that's an interesting thought too. As this rule comes out, we'll want to engage with your health insurance providers to see if they will cover that rather than either an employer or employee cost. And then, the question is, if someone has an accommodation, whether for a medical or sincerely held religious reasons, if they are exempted and only have to do the testing, is that something that the employer will have to pay? Probably. If it's a minimal cost, well, that goes into the undue burden analysis that I'll talk about a little bit later. But more likely than not, the employer would have to pay if they are granting a reasonable accommodation for either religious or medical reasons.
Kara, there's a couple other things that we've heard sort of grumblings about out of the agency that point to the employer as the likely entity that's going to be responsible for paying for testing. One is the recognition, and I think we all recognize this is a very likely situation, of employees producing fraudulent, certainly the vaccine cards, we're hearing about that, but I think test results as well, either bringing a home test result, doing it one time and bringing it every week as your proof of a negative test, or some false manufactured lab test result or something like that. And I think the idea would be that there's going to be more control by employers to avoid fraud, which certainly I know OSHA is going to talk about employees committing fraud, but that's what we're talking about, that there'll be a little bit more control if employers are organizing and paying for the testing program, that it would ferret out and eliminate some of that risk. And then the other thing is that I think the president genuinely wants a hard mandate, and he thinks, probably maybe this is true, that if he makes employers pay for that option, which is not, the law doesn't require that you have the second option, that's going to be a minimal, a regulatory minimum that you can, provide, it's vaccinations or testing, but there's nothing prevents you from saying, but we're not going to offer the testing option here at my workplace. And if I've got to pay for all this testing and administer the administrative nightmare of tracking weekly tests, I'm just not going to provide that option. So Biden's going to get his hard mandate, but it's going to be voluntary by employers who don't want to pay for testing. So there's a couple more reasons why we think OSHA may ultimately, is very likely ultimately to put this on employers.
Thanks, Eric. So this is another question that we are getting a lot from our clients, and I can see the chat. I know a number of people have asked this question leading up to the webinar. So I hopefully we can answer this. Again, we still do not know what the final rule will say, but I think we've gotten a little bit of insight from our friends at OSHA. So really, who is covered? We're talking about only employers with 100+ employees, unless you've got, federal contractor, federal, as we talked about, healthcare, that's a hard vaccine mandate. But for everybody else, private sector employees, it is 100 or more employees. And we believe that the employee count is likely company-wide, although there is, good rationale justification for either by establishment, but enterprise-wide. But we are thinking and hearing that we think it's 100 employees company-wide, even if you've got 45 employees in one facility, 45 employees in another facility, 45 employees in a third facility, you likely file an EEO-1 document that, because you have 100 employees, that's how EEOC often looks at it. It's facility-wide, not just location-wide. And so that's probably where we're thinking it's falling. On the other hand, you could look at just by establishment, by a single location, because the argument there is, if this is a health and safety rule and we're looking at protecting the individuals where they are congregating, where they are working, it makes sense that there would only be significant outbreaks where a large number of employees are present. And so it wouldn't make sense to have testing or vaccine mandates unless at a single location. Another justification for this would be that the most recent OSHA regulation impacted by employee count, which is the e-record keeping rule, was based on numbers at each establishment rather than enterprise-wide. But on the flip side, as I said, again, this is a public health initiative. So looking at it more as a traditional workplace safety regulation is to focus on the largest number possible of workers. This is, President Biden's interest to get workers vaccinated. And so from that perspective, we believe that it's more likely going to be looking at employers on an enterprise-wide basis. And then, as I mentioned, not only the EEO-1, but the other statutes that look at employee count, there's some that look at it location-based, some that look at enterprise-based. I think certainly regulation exemptions based on employee count look at company-wide, like OSHA's injury and illness record-keeping rule. So if you're looking, if we're looking at OSHA and the Department of Labor in its entirety, our best guess is that we think the rule is going to come out that it will be at 100+ employees company-wide rather than facility-wide. And I will turn this over to Aaron to talk about remote workers.
Thanks, Kara. And this has been an interesting question. I think one that didn't come immediately to mind, since we've been so focused on protecting folks that come to work and are interacting either with members of the public or obviously with their coworkers. And if you look at the different announcements and the different aspects of what the administration has been doing, as far as the mandate goes with federal employees, apart from religious or medical exemptions, there is no exemption or exception for people who are working remotely. So if you're a federal employee and you're working remotely, you need to be vaccinated, period, full stop, as I understand it. what I'm hearing, I think what we're understanding is that that's unlikely to be the case with respect to the soft mandate that Eric and Kara have been talking about. I'm assuming, and just based on the indications that we've seen, is that if someone is working solely from home and that means they don't have to come into the office with any frequency or regularity. They don't, as part of their job, they're not required to go out and either interact with members of the public or with customers, that they would not be subject to, or the employer would not be expected to require those individuals to get vaccinated. I think there probably will be some sort of a threshold as far as whether it's 85%, as we're kind of predicting here. If you're home 85%, but 15% of the time you're either coming into the office or interacting with customers or members of the public. I don't know if it'll be a strict percentage like that. If it's going to be some other measure, perhaps something that's a little kind of squishier that will give some flexibility to employers. But I certainly think taking myself, for example, I've been working remotely, but as someone who regularly manages OSHA inspections, I've been called to a number of plants for OSHA inspections. Now that OSHA is back doing that again, I've gone out and attended meetings for work. And so I would assume that someone like myself would be someone that that OSHA and the administration would want to get to be required to be vaccinated, assuming we fit under that 100 employee threshold. So one thing that I think we can look at for possible clues to how the administration, how OSHA might address this issue, I've seen a few letters that have gone out to contract companies with federal contracts. Now, keep in mind, my understanding is these rules have kind of varied somewhat from depending on the contracting agency. In other words, the government agency with which an individual company has their contract. So if you're contracting with the VA, you might be subject to slightly different rules than if you're contracting with EPA or labor or some other agency. But one of the letters that I saw talked about the company had been identified as having staff who routinely works in our federal facilities. They were directed to provide a letter to the agency attesting to their current compliance with the requirements set forth in the letter. And the expectation is that the compliance would have to be in place and people would have to be fully vaccinated by November 1st. As far as that vaccination requirement, as far who would have to be vaccinated amongst that company's staff, it was individuals with regular ongoing on-site presence at the federal facility. So that to me suggests someone who might have to go in once or twice just for either one day or a brief visit. There may be some exception, it would appear. Perhaps, obviously, they're going to be required to wear a mask. I don't know if they're going to be required to have a test in lieu of the vaccination. That might be one thing that we see, but that is kind of where I'm pegging it. I think that there will be some. It's not going to be kind of an all or nothing sort of requirement. So the next question that we're getting a lot of as well is, well, what about if we have employees or operations in state plan states? I assume most of our listeners know the difference, but it's about half the country is a little slightly more than half is subject to the jurisdiction of federal OSHA. As you can see from the map up on the screen, those states shaded in blue have what are called state plan states, where a state agency enforces regulations and safety rules that are at least meet the minimum requirements of OSHA. Obviously, states are free to pass more rigorous regulations, as we see in states like California, Oregon, and Washington, and some others. So what's going to happen here if and when this ETS is issued? Certainly, the expectation, the requirement is that all state plan states will adopt the emergency temporary standard that is issued by OSHA. As you can see here, it has to be a rule that is as effective as the federal rule. The majority of the states have done so with respect to the healthcare ETS that Eric talked about earlier, and did so within 30 days of issuance. But keep in mind that each state has a different process to follow. Some don't move as quickly as others. Some states, again, as I mentioned, California can have more restrictive regulations than the federal system. So as far as, for example, who pays for testing in California, it's not just the test, the cost of the test, but also employers are expected to pay for the time that employees spent getting tested. So it can be subject to greater requirements with respect to issues like that. On the flip side, I was talking to the past director of a state plan safety agency in a state where the governor is, let's just say, not a fan of vaccine mandates. And this individual was speculating or thinking that there's a good shot that agency is simply going to refuse to adopt it, or the governor is going to try to intervene and prevent the agency from adopting such a mandate. That sets up some interesting issues. It's not often that OSHA gets involved in issues like that. It does happen from time to time where determination is made that a state plan state is not kind of carrying the water that it's expected to. But that obviously sets up a pretty, I think, meaty and some issue that's going to garner a lot of publicity if you're getting the federal government involved in litigation with the state over this, as we've seen. And I know we're going to talk about towards the end of the program. Arizona, the Attorney General of Arizona has already filed an action. So, I think there are certainly states that we can expect are spoiling for a fight over this. So it'll remain to be seen whether and how quickly such a mandate would be adopted in all state plan states. And I've seen a number of questions coming in fast and furious. This may be a record for the number of questions that we've gotten in a program, or at least this early into a program. But I see that a number of them asked about testing. So, and this is obviously a question that we are getting, or the types of questions that we're getting quite frequently in terms of what types of tests can we use and what are we going to do in terms of the availability of testing. And the president did address the availability and amount of test kits available. The administration has acquired approximately $2 billion in rapid point of care tests, as well as over-the-counter at-home tests for individual use. As many of you may have heard, 3 national, very large retailers have agreed to sell the at-home tests at costs for, I think it's at least 3 months. And the administration has exercised its authority under the Defense Production Act to ramp up manufacturing of these types of tests and assure the continued availability of them. So then the question, though, I think remains that as far as what happens, though, if that's not enough, right? The action plan requires a negative test result before returning to work. And if there is a significant testing shortage, one that is broad, that affects employers in a number of states, for example, we would hope, and I would expect to see, that OSHA would certainly consider exercising its enforcement discretion in permitting employers to allow employees to return to the workplace, perhaps with enhanced precautionary measures. If we think back to where we were at the earlier phase in the pandemic with the critical infrastructure exception, where there's certain times where you could allow people to come back into the office if they were wearing a mask, if they were tested, or if they were screened more regularly, if they were watching for symptoms, if they're socially distancing, things like that. That could be one option. I think you'll have, if it's more of a one-off individual issue with respect to an employee, where the individual simply can't get a negative test, but through no fault of their own, perhaps the promised results were delayed for some reason. I think in those instances, we would recommend that you would use paid or perhaps unpaid leave, depending on the circumstances, while the individual is awaiting those test results. It is important, I think, to emphasize our understanding is that this rule will recognize and allow the use of both types, both the PCR as well as the rapid antigen test. So when we talk about the availability, and I think that's the the retailers that are going to be making test kits available, I presume will be those rapid antigen tests. And so I think we're going to see perhaps significant reliance on those. So that should be an option. But again, I think tying this all back together, I really do agree with my fellow speakers that the cost and the perhaps logistical issues associated with the tests are going to be such that many employers are going to just kind of throw their hands up and say, we're just going with a hard mandate because of all the challenges that testing poses. And I think that the reason for that off ramp, however, is that knowing that there are, I think, those employers that will be concerned, probably understandably so, that they're gonna lose a lot of their, or some significant portion of their workers, that they may well nonetheless decide to proceed with that testing as an alternative option. So then probably another big, one of the more significant questions that we've been getting since this ETS was announced, and really kind of relating to these types of issues throughout the pandemic, as far as documentation of vaccination status, even before it was, anyone was thinking there might be a mandate like this. Because of that record keeping or record retention rule that OSHA has with respect to medical records and the challenges that can pose for employers. So there really are, I think, two types of documentation that we're talking about here. One is documenting an individual's vaccination status, and the second is documenting and retaining proof of the test results. So I would certainly expect that this ETS will address this and hopefully provide some clarity. It's certainly something that I had hoped to see and really didn't, with respect to the guidance that OSHA issued on several occasions earlier this year. If you looked, however, at the federal healthcare ETS, there is some guidance that was provided there, and it, as you can see here on the screen, it recognized a number of ways that employers could approach this requirement with respect to documenting status. So whether it's providing copies of the vaccination card, whether it's a self-attestation, I think there is some flexibility that is accorded to employers to decide how they want to go about doing that. I think, though, kind of touching back on that the potential concern about fraud, I think when I talk to some employers, certainly in those in hospitality, that are welcoming guests into their restaurants where a card is required, or one individual I've talked to with a large healthcare a large health club and gym that is going to be requiring vaccination status. Some of the members had raised concerns like, well, we think that people are going to be very likely to submit false, even the cards themselves. We've seen, I think, most recently of some Vermont state troopers were accused of selling false cards. There was a pharmacist accused of selling false cards. We know they're out there. So they're in addition to the potential obtaining either viewing and recording proof of the cards through looking at someone's card and then creating a log of that, or asking them to submit copies of the cards themselves. A number of states here in Illinois, where I live, you can access your vaccination record on the Secretary of State's website. I've had a few clients that have asked whether that would be an option for them to go that route, so they don't have to deal with the cards. They could just get access to the individual, or have the individual show them that screen, and then I think that would be sufficient for them. So that's something else that they're considering. So then on the last screen, again, just to summarize, one option would be making a copy or taking a photo of the vaccine card or the test result using a self-attestation form, and you can use that, I think, just as easily for the test results each week as well as for the vaccination status. Or, as I said, just viewing the records and then creating a log. I think that's typically how we've been approaching it. I think the most common approach that the clients that I work with are using, so they can avoid having to keep those copies. One thing that I think we're hoping to see, however, is perhaps something in the rule that would specifically state that if you keep copies of the actual card, that will not be subject to OSHA's employment plus 30-year retention requirement. That would be a logical, common sense compromise from my perspective. Keep in mind, however, also that while the EEOC permits collecting this data, that it does have to, like any medical record, accommodation requests and things like that involve medical information, all that should be kept in separate files apart from the individual's personal record and kept in a secure location under lock and key. So that, I think that is all I am going to talk about, and I'm going to turn it back to Kara.
Thanks, Aaron. For those that are going to have the vaccine mandate, you need to make sure that your policy, and it really should be a vaccine policy that's written and shared with all of your employees, because the policy needs to include an accommodation process for individuals that might have a religious or medical exemptions. So according to the EEOC, employers, you should presume that a request for religious accommodation is based on a sincerely held religious belief, unless there exists an objective basis to question the sincerity. We are seeing and we're facing tons of religious exemptions because we think it's much easier for an employee to try and get an exemption under the religious exemption than they might be able to under medical exemption. Generally, under the ADA, you need to be an individual with a qualified individual with a disability in order to qualify for a medical accommodation. But religious accommodations, you really just need to say, I have a sincerely held religious belief, or even a moral or ethical observance, and therefore I would like an exemption. And so we're looking and reviewing and advising clients on a variety of different types of requests that we're getting. It really ranges to, here is a letter from my pastor who feels strongly against the vaccine, and here's why I don't want it, to other very vague, I simply don't believe in vaccines, but yet that they've been vaccinated as a child or they've been receiving other vaccines throughout their life. So you really need to have, you are able to ask questions if you don't think that it is a sincerely held religious belief. Generally, personal anti-vaccination positions will not be sufficient to hold that sincerely held religious belief. But I also very want to caution employers from questioning the sincerity of a religious belief just to avoid running afoul of Title VII's, religious discrimination law. So tread carefully there, but don't feel like you have to accept every single religious exemption, especially if there's things or facts in the exemption form that the employees are stating that can be verifiably false, and you can go back to them and say, there is facts that we have that undercuts your religious belief. So that's another angle that you can go back and ask more detailed questions if you feel like it would be appropriate. And obviously you need, if you do feel like it is a justified religious or medical exemption, you need to follow and provide a reasonable accommodation. Here it would likely be testing. Testing would be considered a reasonable accommodation. It's not the only accommodation. There could be others like remote work or changing job considerations or a variety of different things. But I think certainly testing already would be viewed as an accommodation unless it would pose an undue hardship under Title VII or the ADA. And we've seen the EEOC has already filed suit against an employer in Atlanta for not providing an accommodation to an individual for remote work. So we're closely following that case, but it is the first case that the EEOC has taken on in the COVID-19 pandemic perspective against an employer who did not provide a reasonable accommodation. The undue hardship standard varies, whether it's Title VII or ADA. Title VII, it's whether it's more than a de minimis cost or burden on employer. It's a little bit lower of a standard than the ADA. ADA is pretty high burden to show that it's a significant difficulty or expense. So courts look at a variety of factors in terms of how difficult is it for you to provide this accommodation, and given what Aaron was just talking about, testing and hopefully the availability and the cost of the testing, I think it'll be a challenge to provide that an undue hardship standard is met, at least under the ADA. So let's move to the next slide. So the next thing we're asking, and I know people have asked, made some questions in the chat about this in terms of boosters and natural immunity. So will the emergency temporary standard require a booster shot to be fully vaccinated? You know, our thinking here is that it's unlikely because the CDC has not updated its definition of fully vaccinated for boosters. Could change its guidance. OSHA relies heavily on the CDC guidance in developing its own. And so if the CDC updates its guidance, or if the FDA approves and recommends boosters, you know, we might see something incorporated into the ETS. The FDA just declined to do so earlier this week. So definitely as time is going on, we are seeing new information with respect to boosters, and only time will tell whether this new ETS, by the time it comes out, will require a booster shot. But either way, if an employer does get a booster, you know, you want to make sure that you're documenting that booster as part of your records, just like Aaron talked about, in a confidential manner, kept in a separate employee medical file away from the rest of the personnel file. And at least under the ADA, that only has to be kept for a year. The other question that we're getting is, will the new emergency temporary standard exempt workers with a natural antibody immunity? Those individuals who have already been infected by COVID and they've recovered, they have natural antibody immunity. I heard Dr. Fauci speak about this question and was asked about an Israeli study that had come out recently, saying that people with natural antibody immunity are actually more protected than with a vaccine. And he, had heard of the study, felt that the government needed more time to look at those studies and read that. So we don't think at this time that the ETS will exempt individuals who've already recovered from COVID. And that's largely because the CDC still recommends that even if you've gotten COVID, you should still be vaccinated. And unless CDC changes its guidance in that regard, we think OSHA will follow that, again, because they rely heavily on the CDC guidance when it's developing its own ETS. The healthcare ETS does recognize natural immunity in some contexts. So again, this could be a wait and see, and it also could be an area of opportunity for industry to give its voice to OSHA when it's considering the new ETS.
All right. The other big question on everybody's mind is, when is this going to kick in? When am I going to be covered by this rule and have to take action and start paying for employees' time for vaccinations, or managing what is likely to be an administrative nightmare of evaluating negative tests on a weekly basis? Our one frame of reference is the emergency standard that we watched OSHA promulgate earlier this year. That process took about 5 months total, from the day that the president issued an executive order to OSHA in March to mid-June, when the final rule was published in the Federal Register. It took OSHA about, I can't remember if it was around 13 or 14 weeks to deliver a draft emergency rule to the White House for consideration. And then it sat there for about 2 months, where more than 50 stakeholders, mostly employers and trade groups, but also some union representatives and worker advocates and public health representatives, but over 50 stakeholder meetings over about a period of two months. This one is expected to go quicker. President Biden calls for this emergency rule to issue in the coming weeks, which is a perfectly vague way of not defining it. OSHA has spoken publicly about this a couple of times, and they've used similar vague language. They've suggested the intent is to do it much quicker than the last go round, but OSHA does not do things quickly. I mean, rulemaking in particular is not something the agency has ever done historically very quickly. Looking back at the 14 weeks it took them to deliver a draft to OMB, they talk about, even though they missed the president's deadline by doing that, they were very proud of how quickly they got that done. And in a lot of ways, it was a remarkable feat. So I've heard talk about, 2 to 8 weeks as a possibility to get a proposed rule to OMB. I think that is totally unrealistic. And if that's what, OSHA is sort of flagging for themselves as 8 weeks, I think 10 to 12 weeks is probably the better target. Always add in that extra 30 or 40% of bureaucratic time. But that's been our guess here, is that it's going to be faster than the last rule, but not incredibly, not what we in private industry would consider to be fast and efficient. And then what's going to happen, I think, by law, because it's going to be an emergency standard, is technically it will be effective immediately, but it may be that there is written into the rule a period of time that allows workers to come into compliance with the vaccine piece of this. So perhaps they say, get vaccinated within, it takes, what is it, about a month to get both doses, and then an extra 2 weeks after that before you're considered fully vaccinated. So I could see a situation where the rule is immediately effective, but you've got 6 weeks or 7 weeks or 8 weeks before the testing component of it kicks in. So we're looking at something like the end of December or early in 2022 as a realistic time period for a final rule published, with some period of time after that before the testing kicks in. That's not necessarily how OSHA is going to operate here. They could say, that's fine, you've got these 6, 7, 8 weeks, you've got an indefinite amount of time to get vaccinated, but you've got to start the testing right away. The way that other states and health departments and other organizations have implemented these mandates generally, though, is that the mandate starts as of a certain date, or they announce the mandate and say you've got a certain amount of time to get vaccinated or leave, or undergo a testing program or something like that. But that's our best guess at this point. We'll certainly be tracking it and paying attention to any of the signals we get out of OSHA as to how close they're getting. There's going to be legal challenges to this. This is one thing I can say with certainty because it's already happened. The Arizona Attorney General filed a complaint alleging that the action plan that was produced by the president was unconstitutional on various grounds. That already happened this week. It's sort of an interesting issue of ripeness, right? This is an action plan does not create legal obligations for anybody, and there will be no legal obligations under this OSHA ETS until the ETS is issued. So I don't anticipate that these legal challenges at this stage will get very far, but there will certainly be, I would expect, legal challenges once the rule is issued, and in connection, obviously, with the executive orders for federal contractors and healthcare. The healthcare sector, there will be legal challenges in that regard, or to those actions as well at the appropriate time. The legal challenges could come from all fields. I mean, you could see industry do it if it is an unrealistic set of expectations, and maybe we already know that it is. We could also see a challenge come from labor. If OSHA decides, as I think they should, to place the cost of testing on the employee who's made the decision that OSHA is trying to avoid, and that is the decision to not get vaccinated. If employees are asked to bear that burden, I could see labor bringing a challenge in that regard. And we already know that the state attorney generals are gearing up. One has already filed. They just sent a letter, a collection of about 20 to 25 attorneys general sent a letter to the White House laying out their view that this was an illegal overreach by the federal government. We've laid out here some of the grounds. If we're talking about the OSHA rule itself, it is a pretty steep standard that OSHA has to meet to properly issue an emergency standard. It has to be a grave danger, and this particular rule has to be necessary to address that grave danger. It's kind of an interesting context here with OSHA already issuing an emergency standard a few months ago that didn't apply to most of the industries that are now going to be covered by this new rule. So does that reflect OSHA's already making a determination that this is not a grave danger in all these other industries? Looking at, in terms of necessity, we've got another rule that OSHA just issued that didn't involve vaccines or testing. And so how can it be that this rule is necessary, or how can it be that the prior rule was the only rule, was the necessary rule to address the hazard, if they just made a contradictory determination a few months ago? Now OSHA is certainly going to marshal out the the Delta surge and the change in the landscape. But that's an interesting issue. I think we'll see claims that tying a regulation to the number of employees as opposed to the actual exposure risk because of the work you're performing, because of the interface with potential COVID patients or customers or the public, that using a number of employees is arbitrary and capricious for a safety and health rule. And then obviously the constitutional challenges that we're already seeing some of the states bring. And then finally, there's the big one that, you probably by now have all heard about, the case from 1905, where the Supreme Court said that vaccine mandates are okay, but they're okay at the state level. Now, a lot of people are saying, well, that obviously means the feds don't have the authority. That wasn't the case before the Supreme Court. They weren't deciding whether it was the state or the federal government that has the authority. It was whether the state, actually a municipality, had the authority to issue a mandate at all. This was about smallpox and determined that they did. That doesn't mean that the feds don't have it, but that's going to be a big question that I think is going to be included in all of these legal challenges. And so it's possible that depending on the judge or the judges that these challenges end up before, that this rule is enjoined before it even goes into effect. And that's something we're going to have to track and pay attention to. And frankly, another reason why a lot of people are talking about this rule could come out in 2 weeks or 6 weeks or 8 weeks. I don't think that's going to happen, perhaps even for a strategic reason by OSHA. I don't know if you all have been tracking the headlines over the last few days since President Biden announced the intention to have this rule issue, but a lot of employers are already acting. And I think a lot of them were waiting and hoping to get some cover from the federal government or the state governments to issue vaccine mandates. A lot of them are already doing it. And OSHA knows that. And I think OSHA expected that just by announcing that this rule is coming, that a lot of employers are going to implement these kinds of mandates. And I'm sure that they recognize there's vulnerability in the legal authority to issue this rule. So if they drag their feet a little bit and enough employers implement mandates but voluntarily between now and the date they issue the rule, if the rule gets plopped on ice by a judge who enjoins implementation of the rule, or it gets rescinded because it's determined to be beyond the federal government's authority or OSHA's authority, then at least they've given some time for employers to implement mandates that will have moved the needle on the vaccine numbers before that. So another reason to think about that this might not be as quick as a lot of people are threatening. Last thing we wanted to share with everybody today is, we're all sitting here and watching things change so rapidly with big shifts and this big new development from OSHA. What can we do about it? What can employers do? One thing you can do is make sure that your voice is heard in this rulemaking. And I will tell you that I'm trying to think of another OSHA regulation where there has been a better opportunity to impact the final rule that gets issued than this one. I can't think of another rule where the opportunity that employers get to share with OSHA their considerations comes at the time that the agency is really thinking about the rule for the first time, other than this one. Every other rule, the agency has been batting it around and talking about it, making policy decisions, issuing RFIs and thinking about it and writing and rewriting and crafting and hearing from their constituents on the labor side before employers ever have an opportunity to do or say anything about the rule. Well, here we know that OSHA has barely started working on this rule. There's an opportunity to impact what it looks like. And I think OSHA very much would like to avoid legal challenges, or would like to craft a rule that is not so unpopular, not politically unpopular, and maybe not so unpopular that it faces strong legal challenges. So they're going to hear from us. They want to hear from us. So one of the things that we're doing, we've already done, probably everybody on this call has already gotten multiple emails from me about this. We are reconstituting our Employers COVID-19 Prevention Coalition that has been a broad employer anonymous collection of employers and trade groups across basically every industry of every size, everywhere in the country, to participate in Cal OSHA's emergency rulemaking, to participate in the first Fed OSHA emergency rulemaking, to advocate to OSHA for lots of specific policy interests around record keeping and other issues. And I know that we have had a significant impact on all of those regulatory developments. We submitted, I think, really thoughtful written comments to both Cal OSHA and to Fed OSHA and to OMB about the emergency rules we've already seen. And a lot of what we asked for is in there in pretty close to the exact language we were looking for. We've advocated for and gotten specific guidance, very favorable guidance that was not on OSHA's mind until our coalition got in there and fought for it. We've had success already during this pandemic, during the rulemaking and policy making on the COVID front. So we're bringing a group together right now. We'd love to have as much participation as possible, to hear your input, to be able to collect data and anecdotes and cost analyses that you have experienced during the pandemic that will help us influence this rulemaking. And I'd encourage everybody to participate. We're going to be addressing a lot of different issues, I'm sure, in this rulemaking, but among them, who pays for testing? And if we're paying, and if it's the employer that has to pay for testing, is it just the test or is it time for testing? Who's covered? Is it going to be establishment-based employee count or company-wide? Will there be recognition of natural immunity and exemption from the testing requirement if you've had and recovered from the illness? What records are required to verify and to demonstrate to OSHA the verification of vaccine status or testing status? And if you create those records, if you collect those records, are they covered by 1910-1020, the employee medical record requirement, or can we set a shorter preservation requirement than the 30 years, maybe 1 year like the ADA requires, and a ton of other issues that we know will be important to employers. So I encourage everybody to reach out after this. Let us know if your organization is interested. We'll share more information with you about that. And I can tell you that, you're going to help us impact the final rule that OSHA issues, but you're also going to get a lot of value add service out of that. You're going to get regular and frequent, very detailed updates from us about the rulemaking, often that include, information that is not otherwise public. And then a lot of as much education as we can give, both pre-rule, but also post-rule, helping you come into compliance with the new regulation. I think the folks that have participated in our various coalitions thus far have found them incredibly valuable. And one sign of that is each time we form a new coalition, essentially everybody who has participated before participates again, which is a really good sign. So I'd encourage those that haven't done it before. We've got very small employers, very big employers across all industries, and it gives them a seat at the table. So I'd encourage you to participate. I'll turn to Aaron and Kara, because I think they've been monitoring the chat a little bit, and get your thoughts about whether it makes sense to try and dig through some of the questions we've got.
Yeah, there's been a lot of really great, insightful questions. So if you want to try and address some of them now, and I'm willing to stay on longer if people are as well. We've got a lot of people on the call, so happy to be here. I've seen a couple talking about temporary employees. Will temporary, independent contractors, temporary employees be included in that 100-person threshold? Again, we don't know. I think my thought, and you guys correct me if you disagree, I think it's really going to be the way that employees are defined, in other contexts. So like temporary employees, independent contractors will not be included, but that is definitely a question for OSHA.
Yeah, and I would think it may be handled the way they handle other similar questions, like, does that temporary worker, if they get injured at your workplace, does that injury go on your log, or does it go on the 300 log or the 300 log of the staffing agency? And the question there is, who is supervising that worker on a day-to-day basis? And if this is somebody who may not be on your payroll because they're through a staffing agency, but you're giving them assignments, you're overseeing their work, you're providing them training, you're providing them the tools to perform the work, that's a person whose injury goes on your log. My guess is that's going to be a worker who OSHA would expect you to cover in this regulation as well. And I think it's that kind of analysis is what I would expect to see. But as Kara said, I don't know that OSHA's even thought about that yet, but we'll find out soon enough.
Yeah, I think this is Aaron. I would just add that the related question that I've gotten deals with part-time. So part-time workers are not temps, but they're actually your employees, but just don't work a full schedule, and how they would be included for the counting towards that 100 employee threshold. So I think the most likely analogous law would be the WARN Act, which has provisions for counting part-time workers based on the accumulated number of hours worked at your facility per week, and also kind of the threshold, or I should say the maximum number of employees that you have during certain periods. So I would certainly expect that will be covered, in either in the ETS or any accompanying guidance. So there is some certainty about who is covered.
Yeah. See a good process question here of whether we expect that OIRA and OMB will take stakeholder meetings again. I think the answer is yes. I would be shocked if they didn't. I think it is not going to run for 8 weeks and 50 meetings, but I expect that there will be some opportunity pre-rule for interested stakeholders to have a voice in this. And that's one of the things from our coalition standpoint. I think the agency really appreciated the thoughtful approach that we brought to the prior rulemaking. And so to the extent that there is a limitation on the number of meetings they can take, I'm confident that we will get one of them, that they want to hear from our group. Our group, I think, brought a thoughtful approach to the process. I'm expecting that the rule will sit at OIRA for probably 2 weeks, and it'll allow them to take, they were doing on average 2 or 3 meetings a day during that period. So I think we'll probably see, at least 20 stakeholder meetings about this rule before the rule is finalized. And I'd encourage everybody to participate in that process, whether it's with us or otherwise. I think hearing a unified message or a strong message from industry is really important for this rule.
I just saw one and I'm just trying to find it about allowing unvaccinated employees to work from home. Can you refuse, even if they're able to work from home, can you refuse that request? And I think that question really comes down to, why is someone unvaccinated? Or if they unvaccinated because they have an approved accommodation, religious or medical, certainly work from home could be a reasonable accommodation. And if their job allows them to do that, that could be something that you could allow them to do. And a refusal maybe a denial of a reasonable accommodation. It's really going to be a case-by-case analysis. If an unvaccinated person just doesn't want to get vaccinated and they don't otherwise have an approved accommodation, certainly you can refuse to have them work from home. I think that only comes in an accommodation. Erin, do you think differently?
No, I don't think so. I think that's right. Just consistent with what I've seen in COVID-related inspections throughout this period. The agency wants you to certainly look at, even just from general safety purposes, of who can and cannot work from home. But if someone has if that's the possible basis for an accommodation, I think I agree with your approach. Absolutely.
It's an interesting question about the enforcement aspect of this. OSHA is a regulatory enforcement agency. They issue citations with fines. What do we think that's going to look like here? And in particular, we know that there's talk, I think I don't know if it was in the action plan or where it came from, but talk about that approximately $14,000 per violation. What they're talking about there is that's the maximum penalty today for a serious or other than serious violation. It's about $13,600 or so. Willful or repeat violations can carry penalties up to about $137,000 per violation. And the question I see here specifically is, well, is that $14,000 for not complying with the regulation, not having a program, not verifying status generally, or is that going to be a per employee issue? Now, OSHA does have authority to issue per instance violations, per employee violations, but it's limited it's called their egregious enforcement policy. And they are only allowed to do that if you have a willful violation, first of all. So if it's serious or other than serious, it cannot be per employee, would be my impression. It would be a violation of the standard one time. But if they determine that your violation is willful, and maybe you are out there. We've seen one general duty case where an employer was refusing to allow her employees to wear masks, refusing to allow customers to wear masks, and really just anti any exposure control strategy. So if you get something like that where it's willful, it's egregious in OSHA's mind, they could look, and if the language of the regulation talks about it as a individualized duty, a duty owed to individual employees, as opposed to a broader sort of single act sort of language, then it's possible that OSHA could do that on a per employee basis. And then you're not even talking about the $14,000 level, you're talking about the $136,000 level per employee. You could see some major enforcement actions that way. But I think this is one of these regulations where the hope is that just issuing the regulation, even without substantial enforcement, moves the needle substantially on vaccinations. This is largely going to be, I think, driven by any enforcement we see is going to be driven by employee complaints, and then possibly employers who are swept into national emphasis program inspections. This would be really challenging for OSHA to get out there and enforce without being called in by an employee or a union or something like that, or when there's been an outbreak at your workplace.
Mm-hmm. We've seen a couple questions about labor unions, and you just mentioned that, Eric. And one thing we hadn't talked about is, for unionized workplaces, how does this rule impact them and when it comes out? And what I've been advising my unionized clients is start talking with your labor unions about this mandate, because it will be affecting a term and condition of employment, and labor unions are going to want to be at the table bargaining over it. They can't change the policy because it will be a federal mandate, and most collective bargaining agreements do say that if there's a change in federal law, that the union and the employer will follow the law. But definitely the union is going to want to be at the table talking about the effect of the mandate at the workplace. Questions of testing, paying of the testing, compensable time for testing, a lot of that will be on the table. They'll want to make sure that the policies are applied fairly, consistently, and we've already seen that at least come out from the UFCW when Tyson's Foods had a mandate policy last month. Tyson's Foods issued a statement saying they wanted to start bargaining over that immediately. So I would encourage you to be proactive with your labor unions and start to talk about it, realizing that there may still be some unanswered questions until it's issued. And again, depending on the legal challenges that could have enforcement issues, but definitely engage with the labor unions because it is a bargainable issue.
There's a question here that we've been tackling sort of throughout the pandemic is employers requiring their employees to share vaccination status or negative test or testing status, or status of whether you're infected with the illness. Is that a HIPAA issue? Does that implicate HIPAA requirements? And the answer is, unless you are a healthcare employer or a healthcare provider and you are the one who provided the vaccine, getting into vaccination status or testing status does not implicate HIPAA. If you're a private employer, my law firm, generally, the ADA prohibits you from asking confidential private employee health information in ordinary circumstances because those are protected sort of disability information. But in the context of a global pandemic where the spread of COVID-19 in the workplace is considered a direct threat to the workplace and to the rest of your employees, the EEOC, Department of Justice, OSHA, everyone has made it clear that you're allowed to ask questions about vaccination status, about positive test results and about negative test results. It doesn't implicate HIPAA because you as a non-healthcare provider are not covered by HIPAA, and it doesn't violate the ADA because you've been approved. We've been approved to ask those kinds of questions because of the direct threat analysis. Now, there's a potential pitfall you can get into by asking too many questions, and maybe Kara, you can shed some light on that as our employment expert.
Yeah, I mean, definitely you want to ask people to prove their vaccine status. And as we showed, you can do it a variety of different ways, either through a card or else otherwise at attestation. But I wouldn't then go into other questions as to, well, why can't you get vaccinated, or get more detail about the medical underlying condition. That really is something held, in confidentially with HR, those who need to know. HR knows the limits of what they can and cannot ask. And so you really want to be cautious about training your managers and supervisors on not inquiring into too much detail. And that really then also talks about, training. How important it is going to be to have your employees trained on these policies and procedures, and what your expectations are, what your health and safety procedures will be, particularly in communicating with human resources, not oversharing with other employees, your vaccine or non-vaccine status, or your, testing or not testing. And it, opens up a lot of other questions in terms of when employees may need to take leave, whether for themselves because they're suffering the effects of a vaccine, or if they need leave because, a school is closed or their child has to be quarantined. So there's still a lot of open questions that I think employees will have. So being as transparent as possible with your employees and conducting training and working with them on these questions, I think will be really important for employers to implement going forward.
All right, well, I think we've taken up as much of the day as is reasonable for you all. I really appreciate all these great questions and everybody sticking with us for overtime. We will circulate something of a Q&A document, try and pull out some of the frequent questions or questions that I don't think we've otherwise addressed, and circulate that with a copy of the slides and the recording. But we are available to answer questions and to talk through strategy issues, compliance issues, practical issues with either implementing this ETS or otherwise just dealing with the myriad labor and employment and OSHA issues that we're tackling every day during this pandemic. We want to be a resource for you, so we encourage you to reach out to any of us, Kara, myself, or Aaron, after today's meeting. And I definitely would encourage you to think about and talk about internally whether your organization would be interested in joining our coalition. It's been a great experience sort of collaborating with so many of you throughout the pandemic on the rulemakings and the major policy issues. We've learned a ton from you all, and I think we've been able to share a lot of useful information, usually ahead of public announcements, to help employers in our coalition. So I encourage everybody to reach out if it's something you're interested in. We're going to get going right away. We're going to be setting a brainstorming session with our group the week of the 27th. So let us know as soon as you can if you're interested in participating. And thanks for joining us today.